Welcome to Jester Politics video. Is hate speech protected speech? And again, the short answer is yes, at least in the United States. I thought a logical starting point would be to provide a definition of what hate speech is. Unfortunately, there is no universally accepted definition of hate speech. So after doing some research, I've come up with what I think is a fair definition of this concept. And that is, it's speech that is offensive, insulting, and/or threatening to an individual based on a particular attribute, including, but evidently not limited to, ethnic background, sexual orientation, race, disability, gender identity, sex, and religion. Now, contrary to what a lot of people seem to think, all of that speech is protected under the First Amendment. Of course, just like any other speech, if an individual uses what's considered hate speech in certain ways, it becomes unprotected speech. For example, if a person includes hate speech and incitement to commit imminent lawless activities, that would be unprotected, just as any other speech would be. If a person uses hate speech to communicate an actual threat, that too would be unprotected speech. However, these two exceptions to the First Amendment are very narrow, and neither turns on the words used, but on how you use the words. Simply put, there is no exception for hate speech under the First Amendment. Instead, hate speech is treated like any other speech. You can use all the hateful words you want as long as you're not using them to incite imminent lawless acts or communicate a true threat. Further, nobody should be surprised by this. This dates back to at least 1919 in Schneck v. U.S., when Justice Holmes, writing for the majority, stated that speech is protected unless it creates a clear and present danger. Justice Holmes again addressed the importance of free speech and its breadth in 1929 when United States v. Schwimmer was decided. Holmes wrote, "If there is any principle of the Constitution that more imperatively calls for attachment than any other, it is the principle of free thought. Not free thought for those who agree with us, but freedom for thought that we hate." In 1969, the Supreme Court went even further when it handed down Brandenburg v. Ohio and replaced the clear and present danger test of Schneck with the incitement to lawless action test of Brandenburg, or the Brandenburg test. Under this test, speech is protected unless it is 1. Directed to inciting or producing imminent lawless action, and the speech is likely to incite or produce such action. You must violate both of those prongs, otherwise your speech is protected. Finally, for the die-hard hate speech is not protected speech gang, the Supreme Court decided Mattel v. Tam in 2017, in which it was explicitly held that hate speech in and of itself is, in fact, protected speech. In a nod to Justice Holmes, Justice Alito wrote, "Speech that demeans on the basis of race, ethnicity, gender, religion, age, disability, or any other similar ground is hateful. But the proudest boast of our free speech jurisprudence is that we protect the freedom to express the thought that we hate." But, you say, what about fighting words? That's hate speech, and it's an exception to protected speech. No, not anymore. Maybe in 1942 when it first came out, but since then, fighting word doctrine has been narrowed to such an extent that it's been consumed by the Brandenburg test. So if you don't pass muster under the Brandenburg test, fighting words is not going to cut it. But what about true threats? That's hateful speech. Well, maybe, but hateful speech does not make it a true threat. In fact, in Virginia v. Black, that the Supreme Court decided in 2003, they made it extremely clear that a true threat requires much more than just hate speech or hateful conduct. In that case, they ruled that burning a cross was protected symbolic speech, unless you could prove that the burning of the cross was done with the intent to intimidate. Bottom line is, in the United States, hate speech, as it's loosely defined, is, in fact, protected speech, and it should be. In fact, advocating for hate speech laws is a reactionary position. If we would have had these laws on the books when our nation was first formed, think of what would have happened. The activists involved in the abolitionist movement of the 1800s would have been arrested. The women's rights movement, yeah, they would have been in jail. How about the civil rights movements of the 1950s? Yep, they would be in jail too. And oh, God forbid that you advocated for gay rights in the last few decades. Finally, who in their right mind wants to give the government and some supposed experts the authority or the power to determine what is acceptable speech? For those on the left, ask yourself, do you want Trump determining what you can say and not say? For those on the right, ask yourself, do you want somebody like, I don't know, Newsom, Pritzker, Hochul, Tlaib, AOC determining what you can and cannot say? No, putting up with the few idiots that run around and want to be jerks and racists and engage in insulting and demeaning language is the price we have to pay to have a free and open society. And with that, I'll let you go. I hope you enjoyed the video, and I hope to see you back. Have a good day.